So thank you for that introduction. And today I'm going to be discussing the criteria that an individual must satisfy in order to obtain a catastrophic impairment designation for a mental and behavioral disorder sustained as a result of a motor vehicle accident in Ontario. So since it's easier to understand legal criteria when it's being applied to the facts of a case, I'll discuss a recent license appeal tribunal decision, as well as some strategic approaches you can take to building this kind of a CAT case, and then the key takeaways. So the name of the case is Simmons & Belair Direct Insurance Company. It focuses on the catastrophic criteria regarding mental or behavioral disorders, which is set out in section 3.11, paragraph 8 of the SABS. So in this case, the applicant, Ms. Sarah Simmons, she was involved in a motor vehicle accident on February 15th, 2018. She was traveling on a provincial highway at approximately 70 kilometers per hour and crashed into a tractor, pulling a car out of the ditch on a foggy day. She sustained a concussion and a fracture of her tibia that required surgery. After the MVA, she was diagnosed with several mental disorders pursuant to the DSM-5. She exhausted the policy limits of $65,000 in medical rehabilitation and attendant care benefits. And she alleged that she suffered from a catastrophic impairment due to a mental or behavioral disorder, which would increase her policy limits to $1 million. So the primary issue in this case was, has the applicant, Ms. Sarah Simmons, sustained a catastrophic impairment within the meaning of section 3.11, paragraph 8 of the SABS? So in order for her to prove she sustained a catastrophic impairment, she must establish that she sustained a mental or behavioral disorder, resulting in either 1, a class 4 marked impairment in 3 or 4 areas of function that precludes useful functioning, or a class 5 extreme impairment in 1 or more areas of function that precludes useful functioning. So while assessing the severity of an individual's mental impairment and considering the levels of independence, appropriateness, and effectiveness of an individual, the physician you retain must focus on the effect of the mental impairment on the following 4 areas of function. So 1, limitations in activities of daily living. 2, social functioning. 3, concentration, persistence, and pace. And 4, deterioration or decompensation in work or work-like settings, which is also referred to as adaptation. So the first area is the effect on the individual's capacity to engage in activities of daily living, which includes but not limited to self-care, personal hygiene, communication, ambulation, travel, sexual function, sleep, and social and recreational activities. A physician you retain is not merely identifying all of the individual's activities in daily living that he or she has restrictions. The physician must also evaluate and document the overall degree of the whole restriction and combination of restrictions. The second area is the effect on the individual's capacity of social functioning and interacting with other people, which includes the ability to get along with others, such as family members, friends, and members of the public. Some indicators of impaired social functioning include the inability to initiate social contact with others, communicate clearly, and interact and actively participate in group activities and cooperative behavior, and to show consideration for others, awareness of others' sensitivities, and social maturity. Again, the physician you retain must evaluate and document the overall degree of the whole interference or combination of interferences that the mental impairment has with the capacity of an individual to interact with other people. So in Simmons & Belair Direct, one of the most dramatic changes in the applicant's social functioning after the accident was her emotional volatility, as she became short-tempered, aggressive, and profane. The third area is the effect on the task completion capacity of an individual to sustain focused attention for a long enough period of time in activities to make them meaningful, which requires concentration, persistence, and pacing. In this third area, knowing the history of the individual's ability to sustain focused attention on tasks from both a medical and non-medical sources is of the utmost importance in order to establish a baseline to adequately compare the results from the current clinical evaluations and psychological testing. The fourth area is the effect on the individual's deterioration or decompensation in work or work-like settings, or the incapacity to adapt to stressful circumstances. When an individual with a mental impairment is placed in a situation where he or she faces stressful circumstances in the workplace, the individual tends to withdraw from the situation or decompensate and have difficulty maintaining activities of daily living, continuing social relationships, and completing tasks. While assessing the severity of mental impairment, the physician you retain must focus on which of the following capacities have been retained. So understanding and memory in regards to the capacity to remember procedures related to work, sustained concentration and persistence in regards to the capacity to maintain attention for extended periods of time to complete tasks at work, social interaction in regards to the capacity to interact with other people and coworkers, and adaptation in regards to the capacity to adjust to changes in work or work-like settings. So in Simmons and Belair Direct, the most dramatic illustration of decompensation came from the applicant's occupational therapy report. He did an in-home assessment which consisted of interviewing the applicant and her mother, having the applicant complete questionnaires, and testing her basic physical abilities. He incorporated a situational component to the assessment, which tested the applicant's functional capacities by having her complete everyday tasks. He brought her to a grocery store and provided her with a list of items, as such a community outing is an instructive test of a person's real-life function, because there are more sources of stimulation and stress than inside the home. The applicant demonstrated such significant stress while at the grocery store that the test had to be terminated, which was more compelling and supportive evidence of her incapacity to adapt to stressful circumstances. So while assessing the severity of an individual's mental impairment, the physician you retain must also focus on the severity level of the mental impairment of the aforementioned 4 areas of function by classifying the impairment level in categories. So there are 5 categories or classes of impairment, which are as follows. Class 1, or no impairment, where no mental impairment is noted. Class 2, or mild impairment, where the mental impairment levels are compatible with most useful functioning. Class 3, or moderate impairment, where the impairment levels are compatible with some but not all useful functioning. And then here are the 2 more important ones for the purpose of the catastrophic and designation. Class 4, or marked impairment, where mental impairment levels significantly impede useful functioning. And Class 5, or extreme impairment, where mental impairment levels preclude useful functioning. So let's take a look at the experts in this case. So the applicant relied on 3 experts, a psychiatrist and a neuropsychiatrist, another psychiatrist who assessed the severity of Ms. Simmons' impairments in the 4 areas of function, as well as an occupational therapist who collected information about her functional abilities but did not assess her level of impairment. The respondent relied on 2 experts, a psychologist, not a psychiatrist, as well as an occupational therapist. So when the Simmons and Belair Direct case, the applicant's psychiatrist experts testified that because the respondent's expert was a psychologist and not a medical doctor, in their view, his analysis was focused only on impairment caused by depression and anxiety. They testified that it's important to look at all the applicant's psychological symptoms and their interaction with her pain and concussion symptoms to understand the full scope of her impairment. However, the adjudicator found that the respondent's psychologist did not artificially narrow his assessment of the applicant's impairments by filtering them through the lens of depression and anxiety. So it's okay to retain a psychologist, but you have to make sure he or she doesn't artificially narrow the assessment. So when deciding whether or not Ms. Simmons sustained a catastrophic impairment due to a mental or behavioral disorder, the adjudicator relied on the 3-step approach set out by the Court of Appeal for Ontario in the 2012 case entitled Pastor and Aviva. The 3-step approach asked the following 3 questions. Did the accident cause the applicant to suffer a mental or behavioral disorder? So that's a causation issue. The second branch is, if it did, what is the impact of the mental or behavioral disorders on the applicant's life, the 4 areas of function. And in view of the impact, what is the level of impairment, the classification in the 5 different classes that I mentioned before. So in regards to the first branch of the Pasteur and Aviva test, the adjudicator found that the applicant suffered from mental or behavioral disorders due to the accident. Reason number 1 had to do with the pre-accident diagnoses. Before the accident, Ms. Simmons was not diagnosed with any psychological disorders. Reason number 2 had to do with the post-accident diagnoses. After the accident, various treatment practitioners, retained experts, diagnosed Ms. Simmons with disorders listed in the DSM-5. Reason number 3 had to do with the respondent's concessions. The respondent conceded that the accident was one of the contributing factors to the applicant's impairments due to a mental or behavioral disorder. In finding that the applicant satisfied the first branch of the Pasteur and Aviva test, the adjudicator also expounded upon the applicable test for causation, which is whether the applicant would not be catastrophically impaired but for the accident. In response to Bel Air Direct's argument that the accident was not the sole cause of the applicant's impairments, the adjudicator noted that the but-for test for causation doesn't require the accident to be the sole cause of the applicant's impairments. It only requires that the accident must be a necessary cause of the applicant's impairments, but need not be sufficient in itself to cause those impairments. So in regards to the second and third branch of the Pasteur test, the adjudicator found that the applicant suffered from a class 4 marked impairment in 3 of the 4 areas of function. And in arriving at this finding, the adjudicator heavily relied on the following evidence: the testimony from the applicant and her mother, the testimony from the family doctor, the occupational therapy reports, and the testimony from the assessing physicians. So even though the adjudicator took the expert evidence of assessors into account, he ultimately determined the applicant's level of impairment himself by applying the evidence to the criteria in the AMA guides. This is important to keep in mind because the determination of whether the applicant sustained a catastrophic impairment is a legal question and not a medical one. So the adjudicator rejected the medical opinion of the respondent's experts for 2 reasons. 1, his clinical evaluation was a snapshot in time that captured a peak in the applicant's level of function and optimism. As such, it did not accurately reflect the severity of the applicant's impairments most of the time. He did not properly weigh the additional CNRs he received, which supported the severity of the applicant's impairments. And 2, he only observed the applicant in a controlled environment. The clinical evaluation was held in his office and lasted 3 hours. However, the AMA guides cautions us that a single examination may not adequately describe a person's ability to function in a sustained way, and that it is necessary to review information pertaining to the individual's functioning at times of increased stress. So the biggest takeaway from this recent LAT decision is that the physician you retain, ideally a psychiatrist or psychologist, must reconcile his or her clinical examination, inclusive of standardized psychological tests, with non-medical sources, such as listening to the individual's description of his or her limitations and restrictions, and assigning the appropriate weight to the self-reporting, and relying on non-medical information via interviews of close family and friends and coworkers who witnessed the negative effect of the individual's psychiatric impairment on his or her ability to function. They must also reconcile their clinical examination with medical sources, such as the CNRs of other treating physicians. That covers an adequate period of time prior to the date of the clinical examination, as well as an occupational therapist report, which must incorporate a situational component of the assessment via community outing that tests the individual's real-life function of capacities outside of the home, where there are more sources of stimulation and stress, and detailed descriptions and recorded observations of the individual's activities of daily living, social functioning, concentration, persistence, pace, and ability to tolerate increased mental demands, i.e. stress. So lastly, just don't forget that Section 3.11, paragraph 8 of the SABS does not apply if the insured person sustained an impairment as a result of an accident, unless 2 years have elapsed since the accident, or a physician states in writing that the impairment is unlikely to improve to less than a Class 4 marked impairment. So if an insured is trying to obtain a CAT designation within 2 years of an accident, then a physician must state in writing that the impairment is unlikely to change substantially and by more than 3% in the next year. I say 3% because the AMA guides defines permanent impairment as an impairment that is unlikely to change substantially and by more than 3% in the next year, with or without medication, which was confirmed in a recent LAT decision called Applicant and RSA Insurance.